welcome to Bloomberg Quint. We are here to discuss the key outcomes and implications of those outcomes as the SEBI board meet concludes in Mumbai here today. Several important decisions taken by the SEBI board with regards to the infamous April 10th circular in the context of foreign portfolio investors and the KYC requirements. There have also been some changes to SEBI's consent mechanism. Certain agenda items that were not anticipated and have been concluded in the SEBI board meet today is with regards to the delisting regulations as well as reclassification of promoters. We'll tackle each of these one by one with Abhimanyu Bhattacharya, who's here with us in the studio. Abhimanyu, thank you for joining Bloomberg Quint. Abhimanyu, let me start with the biggest agenda item that has kept the whole foreign portfolio investor community, NRIs, OCIs on their, very nervous. The April 10th circular is what I'm talking about. While the SEBI press release doesn't detail as to what changes can we anticipate in the final circular, principally SEBI seems to suggest that it has accepted the recommendations of the HR Khan committee, which in my understanding what the committee had recommended that let us lay down the requirements for KYC purposes, but not apply those same requirements as to the investment limits of FPIs. Is that your understanding? And based on what the limited, insight that the press release gives us, what can be hoped on this front?
Sure. So from an FPI perspective, I think SEBI has agreed with the recommendations of the Khan committee. I think that gives a breather to the FPI community, and I think this was largely expected that they will, that the SEBI board will take this into account when arriving at its decision. The important part to understand, as you've correctly mentioned, is this is largely to do with the KYC requirements of the FPI, the beneficial ownership, etc., and not to do with the FPI investments per se in the Indian companies. In relation to the Khan committee report, I think they alleviated certain concerns from the April circular that the NRIs, OCIs, RIs can, as a single entity, hold 25% of a particular FPI, and on an aggregated basis, not more than 50%. And the other concern that was alleviated through the Khan committee report was that the NRI, OCIs, RIs, they can, as long as they're asset managers, they can control the fund, but as investors, they shouldn't be in control of the fund. I think these are the two key things that kind of alleviated the concerns that the FPI community had. And one of the other things that was made redundant was the person of Indian origin construct, because in any case under our foreign exchange regulations, that construct doesn't exist. So that was dropped from the Khan committee report suggested should be dropped. I think we'll have to wait for the details of the final circular to come out. I think in the SEBI meeting post the board meeting, I think the chairman was very clear that we'll have to wait for the circular to come out to understand the details. So I think that even the press release that SEBI has put out does not really get into details of what the
No, it doesn't.
And
I don't know if you could glean anything from what the chairman said on because the April 10th circular also sort of impacted India-based asset managers who were controlling some of these funds which are set up abroad to attract NRI investment. I don't know if you could glean from anything what the Khan committee report had said or what the chairman said in the board meet today as to how, because some of these funds had wound up, as a result of this circular. Do we know anything on how they can be impacted?
Unfortunately, not very clear from what the board meeting had to say today about on that front. I think there were some questions from the press who were present at that meeting, and the chairman was very clear that we'll have to wait for the circular to get into the details.
Okay, all right. We also have Sumit Agrawal, who is a former SEBI official and founder of Regstreet Law Advisors, joining us on the phone line. Sumit, thank you for joining us here. Sumit, we discussed the KYC requirements for FPIs in a little bit degree of detail, but considering we don't have anything on that much, I think we will have to get into the details once the circular is notified by SEBI. But I do want your comments on what the regulator has come out or the board has come out with on the settlement or the consent framework front. And, the expectation was, as the committee had recommended, that several egregious violations of securities law, whether it's fraud or FUTP or insider trading, can be included in the consent framework if they qualified certain conditions or riders that the committee had suggested. That approach doesn't seem to have gone down well with the board. And as the chairman said, that they have left it at that if at a principal level the committee thinks or the board thinks that there has been a wide market impact, those violations will not be open for consent. How are you reading this principle-based approach that the board has now agreed to?
Well, Payaswini, the way I see the press release today, that it has gone a move ahead, which can be settled. Now, the major difference which I am seeing is that they have introduced a provision where settlement with confidentiality is going to be provided to the person who gives material assistance to SEBI. This is something like Section 306 of Code of Criminal Procedure, where gives information regarding an commission of an offense is provided protection under law. This is something which is very welcoming. However, with respect to how SEBI is not going to settle certain proceedings where market-wide impact could be there, investor loss could be there, or integrity of market could be affected, how that will pan out to be seen. Because the current criticism of the regulations was a non-uniformity of certain settlements. In certain cases, SEBI had settled, while in certain other cases, SEBI had not settled certain violations. How that is going to be dealt with, that is a moot question here. And details are not yet out, so we are eagerly waiting for the details.
Okay, Sumit, I was reading some of the earlier sort of consent applications that SEBI had accepted, and in one of the case it was a disclosure lapse, the other it was a disclosure lapse as to the severance package of a key managerial person. The disclosure lapses are kind of some of the sort of violations that SEBI has consented to in the past. Given that now SEBI has come up with this approach on this what impacts market integrity, is the umbrella now too wide for, let's say, the market participants to gauge that whether or not a violation is consentable? The some degree of certainty that you had so far that, okay, fraud, FUTP, insider trading are not consentable at all. But now this opens up a whole gamut of, violations that is now at the discretion of the high-powered committee, to entertain an application or not. So are we wiser after, this decision of the board today that let's look at market integrity as a benchmark to see whether we want to entertain an application or not?
Well, Payaswini, I think the answer to that will actually come if some criteria are provided in the form of text of regulation. As on today, those details are not out in the press release. But my sense is that some criteria will have to be provided where the regulator is going to exercise its discretion, what it is going to consider as settleable fraud and what it is going to consider as not settleable.
Abhimanyu, I want your comment on this settlement with confidentiality. And this is something that the US SEC has, grappled with in the past. Earlier, they allowed such settlement without the admission of guilt. But then I think in the famous Citibank case, Judge Rakoff said that you can't go on settling these egregious crimes without admission of guilt. We seem to be following the earlier SEC approach now, or leaning towards that, some crimes or violations will be, settleable without admission of a crime. Is that a healthy approach?
See, I think given the offences that the new consent mechanism is trying to settle, where and this is what even the chairman mentioned, that SEBI's record of actually prosecuting insider trading cases have been far less than satisfactory, and it's largely to do with the evidence and the details that SEBI can gather. So the confidentiality clause, as what has been described in the settlement mechanism, is essentially for whistleblowers who may have colluded with the relevant person to come forward, present evidence, and essentially settle their cases under the cloak of confidentiality. So, and if you see the Dawe committee report, which actually proposed the confidentiality clause, they mentioned very clearly that this is this is a page from the playbook which the Competition Commission uses for
regulations.
Against cartels. So from that perspective, the Dave Committee examined various mechanisms which are available globally, whether it's the SEC, the CFTC in the US, and also our CCI. And they proposed that we should go with the CCI approach in relation to confidential settlement, primarily because both the regulators can exchange their experiences of how CCI has been dealing with this, and then SEBI can learn from that. I think it's a positive approach, because there are cases that where SEBI needs to gather the relevant evidence, and SEBI has been finding it difficult, particularly in relation to close cases in insider trading matters. So from that perspective, if this helps SEBI to get where it wants to be, then I think it's a good approach.
Okay, all right. Sumit, I want your comment on the amendments to the FUTP, Prevention of Fraudulent and Unfair Trade Practices regulations, and they have expanded the definition of dealing in securities to include employees and agents of intermediaries, and strengthening the deeming provisions for fraud to include activities such as misleading information on digital media, front-running by non-intermediaries. Currently, what we thought as dealing in securities was when you actually trade in securities, was my understanding. What does this expansion of the definition mean?
Well, if you allow me, I am going to give one positive feedback and one negative feedback on this.
Please.
When Supreme Court has passed 2 orders, and the way I see this press release and this amendment to FUTP regulations is a replica of certain paragraphs from those 2 judgments. One judgment is SEBI versus Kanhaiya Lal Patel, which was basically talking about how non-intermediaries can be covered in the definition of front-running and FUTP scope. Second was the judgment where Supreme Court had held, since the threshold of proof is very difficult to be found by SEBI, so a screen-based trading system or anonymity of any second party who is a counterparty to any trade is not a defense to the charge of FUTP. Certain paragraphs from those judgments have been put in the form of these regulations. Well, Supreme Court says so, that has been applied, and that's where the regulations have come. But the way the press release reads, it has made the scope very, very wide.
So give me instances of, let's say, activities today that weren't getting sort of covered by the FUTP regs and will now be, come under the purview of the regulations?
See, for example, if somebody were to put in a blog seeking an inside information, and there was no trade or there was no evidence of trade by anyone on that, this activity was not being covered in the definition of an investment advice. This was not covered in terms of the Regulation 3 of insider trading regulations today. So SEBI was trying to cover it by way of an interpretation in the general clause of FUTP regulation. That has been made clarificatory, and by dealing in securities, such kind of an activity will be covered as a deemed fraud.
Okay, something like your WhatsApp forwards which sort of lead to or may not lead to or passing of that information, is that also sought to be covered under this?
I think what they have tried to expand the definition of dealing in securities to also include non-intermediaries. Right, and I think that is something that we should also, which is in fact one of the the WhatsApp cases that we have been seeing. It's the exchange of information in relation to listed scrip, where the people who are exchanging information are not intermediaries per se, but otherwise involved in the stock market. So we'll have to see the details of how this is spelt out in the final regulation that is to come. But you're right. I think one of the focused effort was to actually try and capture mis-selling of securities through information which is transmitted over digital media.
Okay, all right. Abhimanyu, Sumit, I'll let you go for now, because for the lack of the details in the press release itself, because we will have to go back to the circulars as and when SEBI notifies them to understand where the implications or the ramifications of those are. Thank you so much for joining us on Bloomberg Quint, and thank you so much for watching.